Welcome to today's webinar. Welcome to today's webinar. I can't even get the first sentence out. My name is Dominic DeMatties, and I'm a member of Thompson Hine's Employee Benefit and Executive Compensation Practice in our Washington, D.C. office. I am joined today by my colleagues, Kim Wilcoxon and Nate Ingraham, both of whom are members of our Employee Benefits and Executive Compensation Practice. Before we begin, a few housekeeping items. Today's program is being recorded, and we will send a link to all attendees, including the presentation slides, within 48 hours of today's presentation. If you have any questions during the webinar, please feel free to use the question box located in the control panel on the upper right side of your screen. We will answer as many of the questions as we can, either during or at the end of today's webinar. Today's webinar is the first of a four-part series focused on ERISA fiduciary obligations with respect to health and welfare plans. Today, we will set the table and cover the basics at a higher level, including who is considered a fiduciary, fiduciary duties and delegation of fiduciary duties, and begin to highlight some recommended fiduciary practices for health and welfare plans. Future webinars will include deeper dives into many of the substantive health and welfare responsibilities. Kim has done a tremendous amount of work behind the scenes here, helping to organize this webinar series. So we wanted to start by turning it over to her to provide a more robust overview of what we intend to cover during the series. Kim?
Thanks, Dominic. So we are going to have 3 more webinars after this one, where we're going to do a deeper dive into some of the topics that health and welfare plan fiduciaries should be familiar with. As we go through the overview today, we will be pointing out some areas where we plan to spend more time. So if you feel like you've gotten short shrift today, log back in. Our next webinar will be Wednesday, April 10th, where Amy Gerbic and Ed Redder are going to talk to us about a couple different topics. One being following the plan document. We know we always get those requests from participants who want to do something special, or you get some pressure from an executive to handle a denied claim in a certain way. We'll talk a little bit about dealing with plan exceptions. And then also, big item of the day, prudently selecting and monitoring service providers and evaluating health plan fees. On Wednesday, April 24th, my colleague Meredith Kimmelblatt and I will be talking about all things prescription drugs, things you should know, including prescription drug pricing and contracting with PBMs, compliance questions relating to prescription drug cost sharing, and then also touching a little bit on some state law issues with ERISA preemption. Our last session, session 4, will be Wednesday, May 8th, where Michael Dernwald and Beth Mandel will talk about a number of different compliance topics, including coverage of gender-affirming care, mental health parity, cross-plan offsetting, and HIPAA privacy and security. So you won't want to miss any of those webinars. I do want to just note, if you got the invitation to this webinar, those separate webinars require separate registrations. So just be sure that you have registered for each one. Each one you register for, you will automatically receive the slides and the recording after the webinar, whether you attend or not. Back to you, Dominic.
Thanks, Kim. So we're going to start today's session just with a little bit of, like I mentioned at the beginning, kind of a bigger picture, higher level framework or context for why we're doing this and what's kind of going on in the world with respect to health and welfare benefits on the ERISA fiduciary front. And so a logical starting point is just looking at the historical context in which we're operating. Many employers have historically had a more formal fiduciary governance structure in place for their retirement plans than for health and welfare. And that's largely, at least in our opinion, or at least my opinion, it's largely due to outside forces. I mean, you think about ERISA, like the Employee Retirement Income Security Act. Like, why does a law that's titled Retirement Income Security Act even cover health and welfare plans? And, as I understand it, I wasn't around back then, well, or maybe I was, but I was very young. That's because, first off, health and welfare plans got thrown in, as I've been told, almost as an afterthought. But part of the reason was because at the time, an ERISA had been at least a 10-year process in the making, but there was a lot of activity, but most of this was occurring, or at least a lot of the substantive part of ERISA coming together, as I understand it, was during the Nixon administration. And there was significant efforts being made at that time for some type of healthcare legislation, some type of nationalized healthcare, if you will, including proposals from the Nixon administration that, you know, as some would tell it, were defeated maybe only because the countervailing forces of the other party at the time were for single payer. So it's interesting to think about that historical context in particular, given where we've been over the past 50 years. You know, and because of that, and then also just thinking about the structure of ERISA, you know, as enacted, you know, in subtitle B of Title I, we had 5 parts, none of which was specific as to health and welfare. Of course, there's definitions and reporting and disclosure obligations in Part 1, but then Part 2 deals with participation, and Part 3 deals with vesting. Part 4 deals with fiduciary responsibility, which was obviously the focus of this webinar series. And then Part 5 deals with enforcement. And of those, yes, reporting and reporting obligations apply to health and welfare plans and fiduciary duties, as we'll talk about. But there really wasn't anything specific. That Part 6, dealing with COBRA, there wasn't really anything specific as to the substance with respect to health and welfare benefits until 1986. And then, of course, Part 7 comes in, I believe, in 1996. So even if just thinking about ERISA as enacted, the context of the time, that informed the agency focus, right? So the Department of Labor and the IRS and PBGC, well, they were focused on this being a Retirement Income Security Act. And so a lot of the guidance that came out was with respect to retirement plans. And a lot of the enforcement as it eventually came to pass was with respect to retirement plans. And so there really wasn't a lot of focus on health and welfare, even though the basic framework of the fiduciary duty requirements, you know, apply equally with respect to health and welfare plans. You know, another aspect is that we often, you know, there's plan asset questions, which we'll talk a little bit about, but, you know, we often don't have a trust. And, you know, even if you think about ERISA's fiduciary duties, well, I mean, I think it's pretty commonly stated in at least Supreme Court cases that ERISA fiduciary duties are grounded in the common law of trust. Well, the common law of trust, you know, frequently would deal with, you know, amounts being held in trust, right? And we don't have that in many health and welfare arrangements. And so, you know, I think it made it historically kind of difficult for people to fully understand, well, okay, well, how do these fiduciary duties apply in these situations where we have plans that don't have money sitting around that a fiduciary is responsible for taking care of? That then informed the risk, right? And, you know, as things have come to pass, we've seen a lot of litigation. And of course, the agency focus and enforcement was again on retirement plans, which, you know, all of this kind of colludes, if you will, historically to have made it a lot easier to see the issues, in particular with respect to fiduciary duties on the retirement side than it has been on the health and welfare side. So as Kim teed up, you know, here's where we are, and we've put together this webinar series to kind of talk about some ways of responding to this current state. We've got some outside forces. There's been legislation, you know, again, obviously COBRA and HIPAA, but then more recent legislation after the ACA and lots of other legislation that the details of which will be the focus of future webinars in our series, that are pushing harder on the health and welfare side. And that's led to litigation. It's led to enforcement activity from the Department of Labor. And it's been pushed very hard from those perspectives without, of course, for those of you who also work with retirement plans, without any backing off on the retirement side. And so, you know, and it's through that type of these legislative changes, these enforcement actions, cases that are brought, that can help to clarify, that can help to see, okay, well, what are some of these fiduciary responsibilities and how might we improve upon our processes with respect to them? One important thing, you know, that we wanted to emphasize is that, you know, I think, you know, you may see, or I think I've seen a lot of literature and folks talking about, well, hey, you know, go set up a committee. Here's 5 steps to take. Here's how to respond to these lawsuits. here's how to respond to this increased enforcement activity. And I think it's really important to understand that, like many things in life, right, one size doesn't fit all. Where you may be, where any individual employer may be, could be in a very, and is likely in a very different place than other employers. And so, kind of picking up a generic checklist, if you will, probably isn't going to be the most productive way to figure out how you may want to respond. There's a big difference. The other thing to keep in mind is that there's a big difference. I started out by saying, in the prior slide, that many employers have had a more formal process on the retirement side. I didn't say more robust. I didn't say better. I said more formal, and that was on purpose, because there are plenty of situations where the processes that are in place may very well work, but they're not formal, and that can lead to risks and to issues that you may have to contend with, even if you're doing essentially what you should be doing. So just something to keep in mind. So what are some of these current emphasis things that have been coming up? We've got lawsuits challenging health plan fees. I believe this is going to be covered, and Kim is going to correct me if I give the wrong webinar numbers. I believe this will be covered in our second webinar, the next one in 2 weeks. We've got mental health parity litigation. So we both got the plaintiff's bar here, and we've got DOL enforcement. We also have DOL enforcement on health plan fees. That'll be covered in the fourth webinar in the series. Cross-plan offsetting challenges, again, litigation and DOL activity. That'll be covered in the fourth webinar. We've seen challenges to wellness plans, non-discrimination challenges. I believe this was a class action dealing with a tobacco surcharge, that you must provide a reasonable alternative, and the surcharge must be returned if the alternative has been completed. And this is not a new requirement, but in some cases, folks, at least the allegation is they weren't complying. We've got.
I think that's a good point to note, that in some of these cases, we have a new law, we have something we're struggling with, we don't know how to deal with it, and so we're afraid of how the plaintiff's bar is going to challenge that. This, I think, is a good example of a situation where the fiduciary should have known. There are some things out there where the law is fairly clear and the fiduciary may not be paying attention. This is a good example of that, because in this lawsuit, it's very, and hopefully everybody on the call agrees with me that this has been very clear, that if somebody engages in a reasonable alternative under a HIPAA wellness program, that they're entitled to the full reward for the year. You had an employer here who was only providing a prorated reward once somebody completed a smoking cessation program. And those of us who have been paying attention to this knew that that was inappropriate. So this has been going on, clear for years. Don't know why this is happening with this particular employer, but it's a good example of what we'll talk about in just a little bit, of making sure the fiduciary is informed, not only about what's going on with the plan, but about what the law requires of the plan.
Absolutely, thank you. And then just moving through this list on the transparency requirements, I think this will be covered between, Kim, a few webinars, right? These items probably, at least in webinars 2 and 4, but probably 3 as well.
Right.
Yep. And then we've got, these last couple, and all of these, again, are both litigation risks and Department of Labor enforcement actions. These last 2 are specifically listed as DOL national enforcement priorities. And this first one, emergency room services, that really deals with non-compliance issues or allegations of non-compliance with the ACA's emergency service provisions, where the claims are being denied based solely on a diagnosis, or coverage is being limited, allegedly in an inappropriate way, but based on certain timeframes after the onset of symptoms, or allegations related to non-compliance with respect to reimbursement of out-of-network claims. And then the last, this is something that we've seen on the retirement side as well. The idea that the Department of Labor, is working really hard to get at the service providers, if you will. And, part of this is, and I think it's a difficult position to be in, but part of this has to do, at least on the retirement side, with the fact that, service providers, they do so much, right? And the Department of Labor recognizes that service providers do so much. And so they work very hard, let's just say, they work very hard to try to find ways to try to get the service providers to be on the hook, if they can. So just thinking a little bit and focusing a little bit on the Department of Labor's enforcement responsibilities. So the Department of Labor has enforcement oversight with respect to employee benefit plans, as you can see, covering 153 million people. On the retirement side, it's about 765,000 plans. I think this is based on Department of Labor statistics from 2023 fiscal year. So that sounds like a lot of plans. But on the health and welfare side, there's like 3.4 million plans. And, the Department of Labor, so you think about if you're interested in maximizing using your workforce in a way that can obtain results, which we'll talk about in a minute, what those results are or what they intend them to be. There's a lot of fishing to be done, and I don't mean that negatively, but it's just the reality, right? I mean, there's a lot more work that the Department of Labor can, and I believe will be doing on the health and welfare side, just based on these numbers alone. And then you add to that the fact that Congress, in certain cases, which we'll talk about in future webinars, has explicitly directed the Department of Labor to engage in additional enforcement activity with respect to the health and welfare side, at least on certain issues. So what are these enforcement or recoveries and results? Well, this again is from the most recent fiscal year, $1.4 trillion in monetary recoveries. 30% of that is from what those of you who work on the retirement side know as the missing participants program or the term vested program. But that's only 30% of that 1.4 trillion. The rest of it is split between health and welfare and retirement. So when we think about Department of Labor, we often think about the retirement side, but already they're heavily involved in the health and welfare side, and not just monetary recoveries, but also the non-monetary results that are listed here. Elimination of illegal plan provisions, improve fiduciary governance, and whatnot. So with that, I'll turn it over to Nate to give us a summary of fiduciary duties.
Hi, everyone. Great to be here this afternoon. And so I'm going to kick off the refresher on the basic fiduciary standards under ERISA. And I think this is going to help frame the rest of our discussion today, and then also provide some context for future webinars in the series. So talking about fiduciary duties generally, as you know, the fiduciary standards in Title I of ERISA apply to both retirement plans and health and welfare plans. And these rules also apply to many health and welfare arrangements, just a couple examples being HRAs, FSAs, life insurance, but there are many other examples. So who is the fiduciary, or who are the fiduciaries in a health and welfare plan? Well, for starters, at least one fiduciary has to be named in the plan as a plan administrator. And often the default fiduciary of a health and welfare plan is going to be the company. A fiduciary can also be appointed under a procedure referenced in the plan. And so an example of that would be a fiduciary committee appointed by the company. But otherwise, ERISA provides a functional definition of the term fiduciary. So it's really any person who exercises discretionary authority over a plan or plan assets. And so what this means is that a person can be a fiduciary based on the types of activities they engage in. And because of that, it's certainly key to narrow down the fiduciary activities that are taking place in your plan, and then also do some thinking about who's doing those activities. So we're going to give a preview here of just some of the more common fiduciary functions. There are several day-to-day activities in a plan that are going to trigger fiduciary responsibilities. On this list, there are a couple that that really stand out to me in the current landscape, and one is selecting and monitoring service providers. So there can be a variety of service providers in a health plan, your TPA, PBM, and others. And so the selection of these providers is going to be important, as well as monitoring compensation and being on the lookout for any conflicts of interest. And so this is all something we're going to be covering in depth in our webinar 2 weeks from now. So stay tuned. I think claims and appeals is another area that's worth highlighting here. This is another area that involves other parties, because claims and appeals are typically handled by a third-party claims administrator. But there are going to be some fiduciary implications for plans here as well. So I wanted to get Kim's take on this. So Kim, what are some of the things that plans should be thinking about with respect to claims administration?
Yeah, and I think there's a couple things. One is to make sure from a process standpoint that your fiduciary is following the rules that have been set forth by the Department of Labor. So for example, there are some requirements for the content of communications that are sent to participants when a claim or appeal is denied. And we've encouraged our clients to ask their administrators for a copy of the template denial notice that gets sent out. And when we see that, a lot of times we find that the notice is somewhat lacking, or it could be better in some cases it's missing required content. In some cases, it's just not great. And we know that these types of notices are what would be used in ultimate litigation. So working with the service provider to make sure that those notices are more robust, to set a stage, to create the evidence for a future litigation is something that we recommend. Similarly, from an outcomes perspective, especially when it comes to mental health parity compliance, which we'll talk about in a separate webinar, conducting claims audits to make sure that the service provider is actually administering claims in accordance with the terms of the plan and in a manner that doesn't sort of unduly burden people who are seeking mental health care. That's also another activity that we encourage our clients to conduct.
Thanks, Kim. That's super helpful. So I want to move on to another big question in this space that Dominic's alluded to, is what exactly are plan assets? Because when plan assets are being spent, it's more likely that fiduciary responsibilities are going to be triggered. So as a starting point, the DOL's view is that employee contributions are certainly plan assets. There's no statutory definition of plan assets. Otherwise, the DOL said that plan assets are determined by applying ordinary notions of property rights. And they've said this will include any property in which the plan has a beneficial interest. So I want to go back to Kim on this one. Kim, this is a pretty open-ended test. And so when you're working with health plans, what are some considerations that you look at in determining what's a plan asset?
Right. Well, there's a couple different things. One is participant contributions. As you mentioned, participant contributions are plan assets. And I think in the welfare plan context, people sometimes forget that welfare plans have plan assets, especially self-funded plans, because most of the benefits that are paid under the plan are actually paid from the employer's general assets. But if an employer is requiring participants to pay premiums or contributions for a plan, then those contributions, once they're segregated, from general assets, they become plan assets. Now, unlike in the retirement space, where all plan assets have to be held in trust, we do have guidance from the Department of Labor that indicates, if you're taking these premium contributions from a cafeteria plan or through a cafeteria plan, it doesn't have to be held in trust. That doesn't mean they're not plan assets. It just means we haven't segregated them in a separate account or trust. Another way that a welfare plan could have plan assets is if you have a segregated account, if you do set up a trust, then anything that's in that trust is going to be considered plan assets. But there are some cases where service providers will ask an employer to set aside some funds from which the service provider can draw to pay benefits under the plan. And you want to be careful there, because depending on how that is set up, that segregated fund could be viewed as creating plan assets that then generate a trust requirement. So very careful when you're looking at service provider agreements that are asking you to create a bank account or another fund where benefit payments will be made out of. You want to be sure you understand how that should be set up to ensure that those are not plan assets.
Thanks, Kim. That's certainly a lot to think about. It's very helpful. So I'm going to move right along and just do a brief recap of the basic ERISA fiduciary duties. So the first two items here encompass the exclusive benefit rule, or the duty of loyalty. And so that is, I'm sure you know, that means it's acting solely in the interest of participants and for the exclusive purpose of providing benefits. Then moving down the list, there's the duty of prudence, which incorporates the prudent person standard. And so that's also a key duty that we'll talk about today and in subsequent webinars as well. There's the duty to follow plan documents. And then finally, there's a diversification requirement. And this isn't really going to come up much in health plans unless you work with a funded health and welfare plan or a VIVA, but it is something to keep in mind. So thinking a little bit about the duty of prudence. So in general, fiduciaries are required to act with a level of care that a prudent person knowledgeable about those matters would act. And so there are really two components that courts will look at when analyzing prudence. And one is, was there a reasonable process used? So that's procedural prudence. And then the other is, what was the end result, which is also known as substantive prudence. And there's a note on the slide that asks, that posits, what's easier to prove? And my thinking there is that, questions about objective prudence, about results, are for the most part going to require experts weighing in, and which will sometimes lead to a battle of the experts. But I think even more importantly, in a case demonstrating procedural prudence can be a complete defense, regardless of what the outcome is. So it's really critical to have procedural prudence and focus a lot on that. And documenting decisions is certainly going to be a key component of procedural prudence. And on the documentation point, I like to think about some of the lessons we've learned in the retirement space, because there's been an absolute storm of litigation over fees and retirement plans over the past several years. And with all the cases that have been filed, some of them have made it to trial. And there's actually been some recent trials in the past year that have resulted in big wins for retirement plan fiduciaries. And in all these cases, the fiduciaries were able to demonstrate through documentation that plan expenses and the investments in the plan were carefully monitored. And so this has proven to be a winning strategy in ERISA litigation time and time again. Another part of procedural prudence to think about is when you're making a decision, are you getting the expertise and knowledge that you need to make that decision? So you're definitely going to need experts to weigh in on certain issues. And I'm thinking about, consultants, legal counsel, and the like. And I wanted to ask Kim, in this evolving health and welfare fiduciary landscape, can you talk a bit about some of the advisors that you're seeing being utilized?
Sure. The biggest one probably is an advisor on mental health parity. One of the things we're seeing now is this requirement to put in writing how our plan complies with the mental health parity rules. And that really requires an understanding of the science and the process that has gone into creating limits and why would we require prior authorization of this service and not that service? And so you have to look at what the plan has done, both on the mental health side and the medical surgical side, and you have to be able to demonstrate that the processes and the factors and the strategies and the evidence that was used to make this decision on each side of the house is comparable, right? And it wasn't more stringent on the mental health side. Well, we as attorneys don't have the clinical expertise to be able to evaluate whether something is comparable, in that perspective. The employers in-house don't have that expertise. The consultants don't have that expertise. And so what we're seeing is the beginning of an industry of advisors who can come in and work with the third-party administrators and the insurance companies to understand how these limits have been designed and applied, and whether in fact the considerations on each side are comparable. So that's one area where we're starting to see sort of an industry of advisors. Given what we've seen recently, the most recent health plan fee lawsuit alleging that an employer did not do enough to evaluate drug pricing, I wouldn't be surprised if we start to see more of an industry of pharmacy consultants. I know that there are some out there right now, but I don't know that currently clients are taking advantage of their expertise to understand, when you're evaluating a prescription drug pharmacy benefit manager contract, well, should I be getting rebates? Should this be considered a brand or a generic drug? And how does that impact the calculation of rebates? Should I be evaluating each drug independently? Should I be thinking about specialty generics versus, brands? I think that most of us don't know enough about the prescription drug pricing world, but those consultants, the pharmacy consultants who do, could add a heck of a lot of value.
Got it. That's very helpful. I just want to say a couple brief things about the duty of loyalty, which is another, of course, key fiduciary duty. So part of what you're focusing on here is making sure that there are no conflicts of interest present in the administration of the plan. There's going to be focus on making sure that individuals associated aren't getting a personal benefit from the selection of particular service providers. And then it's also going to be important to review issues related to costs, and then other issues as well that impact plan participants, like, for instance, the quality of service that vendors are providing. And really everything under the duty of loyalty needs to be geared toward that purpose of providing benefits to plan participants. And now I want to also highlight prohibited transactions, which are, of course, a key part of ERISA's fiduciary rules. So there are two basic prohibited transactions under ERISA sections 406A and 406B. And so starting with 406A, certain transactions between plan parties of interest are prohibited under ERISA. And so parties in interest could be the employer, plan fiduciaries, service providers, or affiliates or relatives. And so there are a number of statutory exemptions. So even though there may be a party of interest involved in a transaction, there are frequently ways to get it done in a compliant manner. The other type of prohibited transaction in 406B focuses on self-dealing. And so a self-dealing transaction is essentially when you deal with plan assets in your own interests in any plan transaction. Okay, so I want to spotlight an issue that's been coming up in the retirement litigation space that involves service provider contracts and prohibited transactions. And so there's a recent case out of the Ninth Circuit, a retirement case brought against AT&T, an excessive fee case. And so the fact pattern here is that AT&T amended an existing record-keeping agreement to add brokerage services and managed account services. And these were both services that were offered through other third parties But through those arrangements, the record keeper receives some indirect compensation. And the plaintiff sued, and one of the allegations that they alleged, there were a lot of allegations in the case, but one of the specific allegations was that AT&T failed to consider the indirect compensation that the record keeper was getting through these third-party arrangements. And so the plaintiffs alleged it was a prohibited transaction. And in a pretty well-publicized decision, the Ninth Circuit essentially said that the act of amending the record-keeping contract was a per se prohibited transaction. And as a result, the court held that the contract could only be permitted if reasonable compensation was paid. And so the Ninth Circuit remanded it down to the lower court to conduct that assessment. But this case got a lot of press because it's a really expansive view of a prohibited transaction in the context of litigation. Other courts have held that there have to be more specific allegations that transactions involved conflicts of interest or self-dealing to advance this type of theory in court. But this ruling is different because it really puts the burden on employers to defend routine transactions like amending a record-keeping agreement. And there's also language in the decision saying the employer had to consider all the compensation that the record keeper was getting, both direct and indirect, to assess whether the compensation was reasonable and would be exempt under the prohibited transaction rules. So I just wanted to highlight this case because I think the bottom line is that the state of the law analyzing prohibited transactions is really in flux. But I think even though these cases have been litigated in the retirement side, I think it's important for fiduciaries of health plans to keep an eye on how these cases are developing, because theoretically the principles in these cases could also apply to health plans. And as I've said, we're going to keep digging into issues related to service providers in our next webinar. And with that, I'm going to kick it back over to Dominic.
Thanks, Nate. So now we've got a little bit of the historical background and context. We've got a little bit about the law and ERISA and fiduciary duties. Thank you, Nate. We're going to do a little bit more on the basic legal background just real quickly, and then get into the kind of what do we do about it, or what are some steps we can take. So starting this next phase here, just to talk a little bit about responsibilities for other fiduciaries, and you're going to see why this is important in a minute in the next couple slides. But there's really two basic ways that this can come up. You have co-fiduciary liability, which is that about, someone knows about, or an entity knows about, participates, and conceals a breach. Well, that's kind of obvious. The second one is a little bit of a sleeper, allowing another fiduciary to breach their duties by failing to abide by applicable duties. Well, what does that mean? We're gonna talk about that in the next couple slides. But at its basic level, one way to think about this is that if you have a fiduciary responsibility with respect to an ERISA plan and you're asleep at the wheel, you're described in this bullet. Or if you have knowledge of a breach and you fail to do anything about it. Those things are all called co-fiduciary liability. And another way that you can become liable, now there are a process by which a named fiduciary, that's someone who's essentially named in the plan document, can delegate their fiduciary duties to someone else pursuant to a procedure. And once that's been done properly, then that named fiduciary is no longer responsible as a general matter for the breaches of the appointee, unless the appointment is a breach, like the broker is your uncle. You fail to monitor what the appointee is doing, or you somehow become, even though you're the appointee named fiduciary, you become liable as a co-fiduciary under the first three bullets above. Now, as we think about fiduciary conduct, and this stuff can start to sound interesting and scary at the same time. I mean, it's important to remember, that not all conduct is fiduciary. A company when you act as a fiduciary, you have all of these fiduciary duties, responsibilities that we're talking about, and more. But when you are setting up a plan, when you act as the settlor of a plan, as it's called, the sponsor of the plan, well, that's not subject, that conduct is not subject to fiduciary duties. It's subject to legal requirements. There are legal constraints on plan design, but not fiduciary duties. So, you know, and you can have people serving in multiple roles. This is so-called dual hat theory. But when someone is acting in a fiduciary capacity with respect to fiduciary duties, their loyalty, they have a duty of loyalty to the participants and beneficiaries, and they cannot have a loyalty to the company, to the plan sponsor, or to themselves, or to others. And that's really what's described here. Now, one of the things we're going to talk about is setting up some type of fiduciary structure. And one of the reasons why it's important to set up a structure is that can help establish guardrails between fiduciary and settlor conduct. And then again, settlor conduct is really just the amendment, modification, termination of a plan. You know, when you do that, the plan can be set up in accordance with the company's interests. And you know, also decisions on how to fund a plan. Now, decisions regarding how to use the amounts to fund a plan, those are fiduciary, but the funding itself is not. So what do we see? Well, as Nate mentioned earlier, there's generally 3 ways to become a fiduciary. You're named in the plan, you're appointed pursuant to a procedure in the plan, or you function like a fiduciary. You perform fiduciary functions. So you might say, well, how can anybody be accidental? Well, there can be accidental because they don't understand which conduct is fiduciary and which conduct is settlor. And without necessarily understanding the difference between the two, then it can become very hard to understand, well, what is the standard of care? With respect to what activities should I be ensuring that I am acting as a fiduciary and be ensuring that I'm applying, you know, those fiduciary responsibilities properly versus when am I acting as a settlor? So, like, you know, some examples include, like, if somebody is just merely applying the rules for determining when somebody's eligible, they haven't made the rules, they're just applying the rules for eligibility. That's, you know, not fiduciary. If you're just applying a rule, if you're writing the rules, if you're responsible for putting together the rules for eligibility based on an interpretation of a plan document, well, that's fiduciary. So, I mean, that kind of goes to some of the difference that we see. The fact is that when people don't know, or that they are performing fiduciary functions, but they're just not aware of it, well, they're far less likely to engage in a procedurally prudent process that they described. You know, they're far less likely to have, you know, meetings and to put together some type of deliberative process. You know, it can be hard to deliberate with yourself. If, say, for example, only one person is responsible for making a decision, perhaps say service provider selection. And it's also far more likely that one can run afoul of the duty of loyalty, the ERISA duty of loyalty with respect to plan participants. Like, for example, is the service provider selection, to the extent that it's fiduciary, is the service provider selection one that is made because of what the cost might be to the company, or is the service provider selection made based on, you know, who's the best or who's a good service provider to carry out these duties with respect to a plan? You know, it says here maybe, you know, more common on the health and welfare side. I don't know. I'm not sure it's more common on the health and welfare side as I think about it. I mean, it happens on the retirement side too. The difference often is that on the retirement side, again, as you know, stated earlier, there typically is a more formal process somewhere in place, and these decisions ultimately will get picked up by that formal process. And often on the health and welfare side, we don't have that.
And Dominic,
you know, one thing
and say, you know, it's really clear to see a lot of times on the retirement side, because you have your benefits committee, you have your investment subcommittee, you have, you know, they're they have quarterly meetings and they have agendas, and it seems very clear on that side that this is the fiduciary group. And like you said, maybe you've got some accidental fiduciaries on the side, but at least it's there. And on the health and welfare side, up until now, I think it's been a little less consistent across employers. Some employers may have that fiduciary committee that technically has authority on the health and welfare side, but doesn't really exercise it, right? They're more focused on the investments of the 401k plan. And so you have the benefits department who engages in the research to identify the service providers, and they hire the consultants and they look at the pricing, and that group may not necessarily think about the fact that they are engaging in fiduciary actions when they select that service provider. Or probably more common, as I mentioned earlier, somebody comes to them and says, oh, I think I'm entitled to this benefit under the terms of the plan, but the third-party administrator has denied it. Here's my sob story, and then HR feels sad for that person and wants to find a way to provide the benefits or to interpret the plan in a way that gives them the benefits. Well, that would be fiduciary activity as well, that it just may not be clear to the HR or the benefits group that oh yeah, we do have fiduciary duties. We should be thinking about this and documenting what we're doing here.
Absolutely. Right, which goes to the last bullet on the slide, that, if you're accidentally acting as a fiduciary and don't realize it, you're far more likely to not have documented procedural proofs, to not have the documentation. And again, you're also more likely to be unaware of your duty of loyalty. And just a little side note, when we talk about selecting service providers, I mean, one example or one way to think about this is, like sometimes we mix, we meaning all of us in the community mix service providers, and we have service providers who perform dual roles, where, say for example, we've hired a consultant, and that consultant may be doing certain things in assisting, with the administration of the plan. So they may be directed, they're not acting as a fiduciary, but they're being hired to perform functions for the plan fiduciaries that are fiduciary in nature. So those, with respect to those functions, all of these fiduciary duties we've talked about apply. That very same consultant may be also hired by the company to map out a plan design, to think about, well, what will the costs be going forward if we change our design for this in this permissible way or that permissible way, if we restructure our benefits. Well, that's settler, that's not fiduciary. And so, that's, again, just going back to that prior slide and putting it together with this, that becomes a place where it's very easy to become an accidental fiduciary, because to Kim's point, you've got maybe a person in HR or one person who's taking responsibility for hiring that service provider, maybe giving more thought to the activities that service provider is going to perform with respect to plan design, and not necessarily being focused on the fact that service provider has also been hired to assist with plan administration as, again, a directed service provider. And related to that point, Kim, I think there were some points related to fully insured arrangements that you would want to raise.
Yeah, I just want to say, if you have a fully insured plan, that doesn't mean you're off the hook from a fiduciary perspective. Still selecting the insurance company is a fiduciary function, and we still do have an obligation to monitor that insurance company in its administration of the plan. So I think sometimes that companies with fully insured plans say, oh, well, the insurance company is subject to this law and it's subject to that law, so we don't really have to worry about it because they have their own incentive to comply. That doesn't necessarily get you completely off the hook from a fiduciary standpoint, because you still need to make sure that the compensation is reasonable, and that you've selected a prudent service provider.
Thank you. So moving on to, related to the accidental fiduciary is the uninformed fiduciary. And what uninformed here maybe is a little bit of a misnomer. I take full responsibility for that, sorry. Because what it really means is that is a person or an entity not really being aware that it's a fiduciary. They're not informed of their role. They don't understand their role. And we see this again frequently across all sides, but in particular in the health and welfare side, I think it is a bit more common. So this really goes to, and actually this is part of the reason why it was important to focus a little bit on the co-fiduciary liability and also the appointment process that we chatted about a little bit in a prior slide. You step back for a second. Nate told us that a fiduciary can be named in a plan. So, well, who is named in the plan? Who's named in an SPD? Who's named in a Form 5500? But focusing on the plan for a second. Often, the way plans work, or instruments, under which the plan is operated work, is that the employer is named as plan administrator, and that's often that's it. There's nothing else. It'll just say the employer's name is plan administrator. Or there may be the case that nobody is named in the plan document as a plan administrator, in which case ERISA 316 tells us that the plan sponsor, the employer, is the administrator. So now you have a named fiduciary being the employer. And so the question becomes, well, okay, the employer then is a fiduciary. To what extent are they a fiduciary? Are they a fiduciary with respect to all fiduciary activities under the plan? Well, if nothing else has been done, if there's not a procedure in the plan pursuant to which that named fiduciary has, distributed its fiduciary duties or assigned or delegated its fiduciary duties to another entity or person or people, then yes, the employer is the fiduciary. And there's also the question as to kind of what that means for the employer to be the fiduciary. Does that mean the board of directors? Does that mean a compensation committee? And that ultimately will come down to essentially corporate governance. Who in the company has been assigned responsibility essentially to have adopted the plan. And in the absence of any then delegation of anybody else being named as a fiduciary, and whoever there being any procedure by which some other entity or committee is named as a fiduciary, you've got the employer. And so this really becomes a problem because based on guidance from the Department of Labor, sure, you can have named fiduciaries can delegate their fiduciary responsibility to another fiduciary and then only really have to remain a fiduciary for purposes of monitoring and oversight. So if you say have a comp committee that's who has the authority on the corporate side, and they've delegated properly to some other entity to be the fiduciary, well, that comp committee has residual fiduciary responsibility for monitoring and oversight with respect to the fiduciary they've appointed, but they don't have fiduciary responsibility with respect to all fiduciary activities under the plan. But if there wasn't an appointment, even if other people act as fiduciaries, even if a person in HR or some other, even if a committee kind of or loosely is set up, if there hasn't been a proper delegation, then as a technical matter under ERISA, that employer and whomever is responsible, say in my example, the comp committee, they're the fiduciary. So that's where you get into the recommendations, that we'll talk about now. So, at the end of the day, think about, do you want to use a committee structure or do you want to name an individual? But the recommendation is that, personally, I don't care whether we call it a committee or not. I don't really care what we call it. What I care about is that we have proper delegations of authority and that those proper delegations are done pursuant to a procedure in the plan document, such that a named fiduciary has now said, look, these 4 job titles or 3 or this committee or whatever we want to call, or even this person, it can be this person, that's the person who's been appointed to carry out fiduciary duties under the plan. But again, as noted before, without action is the plan sponsor. So why do you do this? Why do you have that process? I mean, in addition to isolating fiduciary responsibility, which is important, and insulating, say, the plan sponsor, whether it's a board, a comp committee, or some other executive committee, this, having a structure, again, whether it's committee or call it committee or not, that facilitates the procedural prudence we're talking about. As I said earlier, it's kind of hard for somebody to deliberate with themselves. So I kind of like to see more than one person on that committee or on that entity or on that body. But it also then brings in all of the learning we have on the retirement side related to documentation of the process, minutes and whatnot. And so it ends up leading to a much better and informed process. You want to consider the use of formal delegations, as we pointed out. I mean, without proving that up, you really are stuck with the plan sponsor being the fiduciary. And delegations can occur through a resolution of the body. Say if it's the compensation committee or say an executive committee that has responsibility with respect to the plan, you can delegate that body can have its resolutions, or a delegation can be included straight in the plan document. So in other words, you can name the fiduciary in the plan document and then name somebody, it doesn't have to, that named fiduciary in the plan document, in other words, doesn't have to be the employer or the compensation committee. So who do you want to serve on this committee or committee-like thing? I mean, I like to see the lowest level people who have the requisite expertise. As Kim mentioned earlier, there may already be a committee in place. There may be a committee in place. I've seen charters that say and where there's proper delegation that says this committee is responsible for all of our ERISA plans, and yet the committee doesn't do anything on the health and welfare side. So that's something we want to, clean up if that's where we are. The other thing, though, is if we have that committee in place, in addition to whatever cleanup we may need to do, are those really the right people for the health and welfare work? Like as Kim mentioned, you may have a fiduciary committee, and that fiduciary committee's main responsibility may be 401k plan investments. Well, those may not be the same people. They may not be the lowest level with the requisite expertise to be handling fiduciary decisions on the health and welfare side. And another thing to consider is then you want to delegate, the committee or the entity or the body or the fiduciary, the people that are doing this work. You still have company employees who will do lots of ministerial tasks. Some people will delegate directly down to a company employee and say, this person is responsible for, enforcing the rules related to eligibility for the plan or ensuring that plan communications are distributed properly. So it'll be a standing delegation. Other times you can delegate essentially through your committee action. So you just basically, the committee makes a decision, or again, the fiduciary body makes a decision, and you document in the minutes. You say, well, Nate is going to be responsible for this. And you list the person either by name or by title. So here we have the scary part, the consequences of failure to meet your fiduciary duties. There could be personal liability. There could be equitable remedies. You could be removed as a fiduciary and barred from ever serving as a fiduciary. The Department of Labor can extract a pound of flesh on a recovery where there's either been a court determination of fiduciary responsibility or a settlement agreement with the Department of Labor. And of course, if you steal stuff from people, you might go to jail. So wrapping up, we'll talk about, there's some best practices here. Many of these we're not going to talk about today because they're going to be covered in future webinars, but they're here for your reading pleasure. Just focused on a couple of them that we did talk about today. Number 1, establishing a committee or a similar structure that meets regularly. Number 5, documenting decisions. And then number 8, paying attention to what's going on in the world, understanding regulatory developments and enforcement activities, what your responsibilities might be. And then number 10, something we didn't talk about, we can hit in future webinars, or we can answer questions if there are any questions on it. Check your fiduciary liability insurance to the extent you have it. If you don't have it, consider getting it. And you might want to make sure that you're covered on the health and welfare side. So with that, do we have any questions that we haven't answered already throughout the course of our presentation?
We do. So if folks want to stay on, we can take those questions and we'll just go over a little bit. If you all have to drop, clearly we understand. But one question that came in, I mentioned the idea of, when you engage with a service provider that's asking you to set aside a fund of money from which they can pay claims, do we have suggestions for how clients should handle that? I mean, really what you want to do to avoid having that fund be considered plan assets is make sure that it is the bank account of the employer. So essentially, the employer should keep that money in general assets and just give the service provider the authority to draw from that. Hopefully that is enough that keeps it as employer general assets and prevents it from being considered segregated. If the service provider is setting up a bank account in their name and asking you to set aside money in there, that could be an issue. I did recently see one service provider who said, okay, well, you have your bank account, employer, that you're maintaining that we get to draw from, but you also have to contribute to our bank account, which we're going to use as collateral. And just in case your bank account, we can't get to it for any reason and we still need to pay claims, then we'll pull from our bank account to pay those claims. And I think there's some analysis and some consulting with your legal counsel that should be, happening in any situation where the service provider wants to pay claims from their own bank account. The other question that came in would be, would you consider the cost savings programs that the major TPAs perform on a claims fall within a prohibited transaction? So this probably gets into a larger discussion that we don't have time for, but the idea being you may have a medical third-party administrator who says, we are going to try to negotiate down with providers. And to the extent we can drive down what the provider is willing to accept as payment, we're going to consider that savings, and we're going to share a little bit of that savings with you, plan or employer. Those are very common programs. That doesn't necessarily mean that they should all be accepted as is the way they're set up. I think that is an excellent exercise of your fiduciary duty to investigate that type of program and decide whether that shared savings fee is an appropriate, and I'm not saying that it is or isn't in all cases. I'm saying this is an excellent opportunity to exercise your fiduciary duties to evaluate that type of program.
Excellent. Thanks. That's it, Kim? Those are the questions?
Those are the questions.
Excellent. All right. Well, thank you everyone for joining us today. As we mentioned earlier, within the next 2 days, you will receive a follow-up email with the recorded webinar and presentation slides. You can sign up for the remaining webinars in the series through the invitation you received or on our website. We hope you found the information today helpful, and we hope you find the rest of the webinar series helpful as well. If you have questions we did not get to today, please email or call your regular Thompson Hine lawyer. If you are not a current Thompson Hine client, please contact any of the three of us to discuss available options that will address your needs. Thank you and enjoy the rest of your day.